I want to thank you for joining us today. Along with my honorable colleagues, Councilmembers Mr. Englander, and I believe Councilman Huizar is joining us. I believe it. This is the Planning and Land Use Management Committee, January 22nd. It's one of those rare occasions where I have one item on the agenda, but it reflects 12 years of work, so maybe that's why there's only one. I'm hoping that we get to a place where we can take some real actions, but it's important to continue moving forward on these items. My understanding is that my colleagues are on their way. I believe Councilman Krikorian might be joining us, as well as Councilman Rosendahl. What I try to do is offer my colleagues the courtesy of speaking at the microphone when they get here, because I know they have other committees and other commitments, and I welcome them to this one. So if we are in a presentation, and I might ask you if we can just pause and allow my colleagues to speak, and then we can continue with their presentation, if that's okay. Roberto, you want to read the first item, please?
Sure, council members. Item 1 is a planning department communication. It has to do with the proposed sign ordinance.
Okay.
And item 2 is the weekly report. I'm not sure if there's a weekly report from Mr. LeGrand.
Our director?
Very briefly, I wanted to make you aware of an excellent meeting we held in the planning department last week. We had the West Adams Community Plan for its first public hearing yesterday. It went very well. We had close to 500 people attend, many of which gave us excellent advice on the plan and their points of view, as well as support for the plan, and various concerns were raised. So we're really happy to have that public hearing and workshop, to see it so well attended and have so many people engaged in the future of their community and what they want it to look like, and how the planning department can be their ambassadors, get their voices heard. So we're very happy to see that plan move forward, and we'll be happy to bring it to the commission and then on to the Plum Committee and the full City Council in the next coming months. That is one of the 3 South Los Angeles community plans we're currently working on. South and Southeast Los Angeles will be following on the heels of this community plan. So we're very excited to see that plan move forward. I'd like to thank Faisal Robles, Ken Bernstein, and their staff, Ruben Caldwell, for moving this plan through and doing such an excellent job, having a very well-attended public hearing in the district. So any questions, I'll be happy to be here to answer your questions.
Not so much a question, but an observation. When we pass the USC master plan, my assumptions are there will be some level of interweaving, if you will, of how these community plans are being addressed. Are my assumptions accurate?
Yes, and as we were working on the community plans for these 3 districts, we also were at the same time working on the USC master plan. So a lot of those already dovetail together. And there's also follow-up ordinances coming forward that we're currently working on called CPIOs, Community Plan Implementation Ordinances, that will mimic a lot of the work that you and your colleagues have done on the master plan for USC. So they'll definitely dovetail together.
Great. Okay. Any questions or observations of our director? Seeing none. Thank you for that report, sir. Okay. So item 1.
Councilman, I should also mention that for item 1, there is a Rec and Parks presentation as well.
Well, let's hear from Rec and Parks first. And colleagues, I believe this presentation hopefully will shed some light as to how the department perceives and wants to implement the opportunities that could be available based on their approach and practice as it pertains to their charge as Recreation and Parks. So, sir, please give us your name.
Thank you, Councilman Reyes. Michael Shaw with the Department of Recreation and Parks. Here today to give you just a really brief presentation on what we believe this distinction is, and hopefully to dispel some of the perception of what we've been doing or trying to do. First and foremost, it just bears repeating, we do not want billboards in parks. never did want billboards in parks. So we believe we're completely in compliance with the sign ordinance.
Can you say that one more time?
We do not want billboards in parks.
Ah, nice and
We do
slow
not
and
want
loud.
billboards in parks.
Okay, all right.
But there is a distinction that needs to be made, and honestly, a picture's worth 1,000 words. So without further ado, let me just want to run through some of the this way here. Which one are you ready? It's not working. There it goes. So this is a Dodger Dream Field, which, I venture to say I believe there's probably one in almost every council district or all parts of the cities. It's just a very simple, this is a scoreboard. These are always donated by the Dodgers. But for clarity's sakes, we need to mention each of these just so that we're in tune with what the legal matters as it pertains to the sign ordinance. All of these go through our Board of Commissioners approval process via a board report, which is reviewed by the City Attorney's Office. And we have had a couple of meetings since the last plum meeting with City Planning and the City Attorney's Office, and we believe we are on the same page. And I think, and we've shared this presentation with the City Attorney's Office as well as members of Planning, and we believe that we are all on the same page. So this is an example of a Dodger Dream Field. This was a playground. That sign is approximately 3 feet in height. It's probably about 5 feet off the ground. But it recognizes all the donors that and the sponsors that built that playground. Here you see different foundations. You see the Los Angeles Lakers. This is on a gym floor in Lafayette Park. This was actually part of an agreement that we did with the Hearts of Los Angeles, which is a nonprofit who does much of the programming at Lafayette Recreation Center on behalf of Recreation and Parks. The money does not come to us, nor does the programming cost us any money. Part of for the Lakers putting their logo on allowing them to put the Laker logo on the basketball court, they in turn gave financial contribution to the nonprofit to run basketball programs at that rec center.
So, and to be very clear, the money coming from these logos does not include the recreation parks, does not go into your budget.
No, it does not.
But it goes directly to the service and the programs that the youngsters and or seniors, whoever the program may be serving, can benefit.
That's correct.
Okay.
In fact, most of I honestly can't think of any that comes to immediate mind, but in general, the mass majority of the money that comes in via these sponsorships or recognition signage is generally goes directly into a capital improvement. The vast majority of them are, a new soccer field or a new backboard or, a new scoreboard. That's not money that we turn around and spend. It's money that's paid for by the donor.
Okay, this is one of those moments I'll ask you to pause. Councilor Rosendahl, if you'd like to speak, sir. Come on up.
Many of them I haven't seen, Mr. Chair, since July 20th when I collapsed.
Well, you're always welcome to this committee, sir.
Well, let me just say this. First of all, I really appreciate your leadership, Ed. You put on and dealt with a lot of stuff over these sign ordinances for years and years and years. And I've had the pleasure of being your seatmate, so I've had the opportunity to really have discussions with you about various things. So first, I want to thank you for helping me get the Tina Maria sign up, which was one of my first involvements in an issue that Venetians are passionate about. To them, sign ordinances and signs and things done by this way or that way are as important in my community as the homeless issues are and the other issues. So I just want to go on record and make a quick statement.
Please.
And it goes like this. For over 4 years, we've been discussing some version of a comprehensive sign ordinance. I strongly support the ordinance before you today and urge the committee to approve it. And while it may not address every single aspect of signage in the city, It is a substantial improvement upon our existing ordinance. A substantial improvement about the existing ordinance. There is nothing that prevents us from exploring future amendments to the ordinance, but we shouldn't hold this version hostage while we explore further refinement. Any refinements can happen on a separate track. I would like to commend the Planning Department and the Plum Committee for the incredible amount of hard work that went into preparation of this ordinance, and again, urge the committee to approve the ordinance today.
Thank you, and a great amount of work was done by the city attorney's office as well, and I want to make sure we don't forget about their role in making sure we can figure out what the courts did or did not want us to do. So,
Yeah, I
finally
got to
at this
agree
threshold.
with you. The city attorney's office has been with us through this whole process.
Right.
And the planning department and people who were in the planning department and in other departments now, and even there you are, of all people, meaning you got a million things on your plate and you're always out here doing it too. So,
Well, thank you, Bill. Thank you, Councilman Rosendahl.
thank you.
Thank you, sir. Thank you for your time.
Give my people love, will you? They're great.
We're trying. We also have with us, and I'd like to welcome up to the microphone, is Councilman Paul Krikorian, who did forward a letter to the committee, and I believe would like to share a point of view and his observations. Welcome, sir.
Thank you very much, Mr. Chairman and members. Good to be with you, and you do have a letter before you from me. I just wanted to stop by briefly and congratulate this committee and the Planning Department for doing such a yeoman's job in trying to bring the sign ordinance to this point. This has been a great effort to try to build consensus through the city, as I think we're going to hear today. And I believe very strongly that we need to move forward today with this ordinance and move this out and get it going. There has been some talk about attaching a further discussion of digital signs to this ordinance. I believe that we should not do that in any way that would delay moving forward today. So I wanted to offer an alternative suggestion to the committee for your consideration, and that's what's outlined in the letter. I would recommend that the committee consider appointing a working group of stakeholders, including neighborhood council representatives, people who have been advocating on sign issues, as well as the outdoor advertising industry, to consider the possible refinement of a digital billboard ordinance, given the circumstances that we're in right now, with the city having significant leverage over that industry, given the legal lay of the land, that we can now may very well be the time when we can develop a policy similar to what has been done in other cities that will significantly reduce the number of billboards across our city, as well as developing community benefits and the possibility of revenues to our general fund. I believe we can do that. But it will take consensus building. It'll take input from communities throughout Los Angeles. And so I would offer the suggestion that this committee instruct the Planning Department to create a working group, including those representatives, to try to develop that as we go forward without delaying action on the sign ordinance that's before you today.
Okay, great. Well, thank you, sir. And it is important to be inclusive in this process as we continue to find ways to protect our neighborhoods while developing a policy that is complementary to the needs of the diverse nature of our great metropolis. So I appreciate that input.
Thank you very much.
Any comments or colleagues? Okay, thank you, sir. Okay. You can wind up again, Michael.
So again, just to recap, this is an example where the Lakers the money's going directly to a nonprofit to operate basketball programs and other programs actually at the Lafayette Recreation Center. This is again pictures, and you'll see a recurring theme. We do a lot of partnership agreements with the LA 84 Foundation, Nike's a strong partner. This is a synthetic soccer field that was put in at no cost to the city. Was donated to this community. I believe that's Ross Snyder Recreation Center, and I believe that's Algin Sutton Recreation Center to the left, or that's a sports court that was put in, again, at no cost to the city. So again, it's not money that's coming to us. A lot of times, the majority of the time, it comes in a form of capital improvement. Of course, we do the Greek Theater, who's a concessionaire. They do a lot of sponsorships for the program. Again, that's revenue that actually that does come back to the department because it's a concessionaire. This is a picture of we use this facility, the Wonderful Outdoor World. These were all the sponsors of this particular program when we actually did run this camping program where we would take disadvantaged youth out into the park system and actually camp in city parks. And we had a number of sponsors that pay for mainly the overtime staff to have people stay in the park all night long. And those were the sponsors that were associated with that. This is a sign that's in Lincoln Park. Again, that was put up by a nonprofit, and that money is going to them. Pershing Square, we do Downtown on Ice. We just had a very successful season, another season of Downtown on Ice, where you see some of the sponsors that were associated with Downtown on Ice. Little Leagues are probably the biggest users of this type of sponsorship, and in recognition to where you see where it says proud sponsors of the whatever Little League it may be, and this is pretty prevalent. I mean, this type of signage is prevalent not just in Los Angeles. I mean, I grew up wearing a Quaker State a uniform. I've never used Quaker State oil for the record, but it had no influence on me. But this is nationwide. This is
What was your batting average? Never mind.
not very good. But anyway, it's just gives examples of this is commonplace in Little Leagues. And again, we in talking with planning and the city attorney's office, we do not believe that this is what the intent of the current site ordinance was to address. Tennis court concessionaires, similar type thing, or different sponsors for tennis. You see Wilson and others on there. These are at this is at Muscle Beach down at Venice Beach, where you see some support so that goes into paying for the programs there. And then we just have a few bullet points. The impacts, if we weren't able to do this, there's loss of funding to nonprofit partners, obviously. Loss of capital funding is a big one to recreation and parks. And again, it's not really us, it's the community it loses out. Loss of sponsorship opportunities and loss of partners. And I would say that generally, I've never had a conversation with a sponsor that said that they wanted anything unreasonable about as far as the size of the sign, things like that. As far as the size of the recognition and things like that, they're always been very willing to work with us. And so I think we can continue to work with them, and under the intent of the sign ordinance to make sure that nothing is violated, or we don't put the city in any position to where legal action becomes a risk as a result of Rec and Parks activity. And lastly, we want to put together Rec and Parks. We never really had the need to basically take those slides that I just showed you and put that into kind of a guideline, but we think now it's probably the time for us to do that. We'd like to take something to our Board of Recreation and Parks Commissioners for adoption to help guide, if it's not me or somebody else down the road that's running the planning and Rec and Parks, to make sure that everything stays within the line with the intent of the sign ordinance. So again, no billboards, and would strictly be taken out. And again, there's never been a billboard in a park. They would have to be in recognition of or of a direct benefit to a park facility or community. So they have to be tied. Whatever we're doing, we're talking about tying it to a benefit to that community. I mean, that's important. It has to be tied to a park purpose. Obviously, we'd be based on governmental speech, thanking the sponsor for sponsorship, for that sponsorship. Obviously, no commercial advertising or any call to action. Again, the message would need to be compatible with park purposes and with our, the department's mission. And all of that would be subject to the Rec and Parks, Board of Commissioners, and that document would be reviewed by the City Attorney's Office before it could ever be adopted, and certainly onto the City Council if so desired. Okay. So, if you have any questions on that, I'll turn it over to planning. Otherwise,
These guidelines memorialize exactly how these signs will appear, and the purpose of these signs will be committed to the programs you've described in this slide presentation.
that's correct. I mean, we need to take, we need to basically describe what I just showed you in words.
And it
Just have a
codifies it
guideline
within
that-
criteria.
Right.
Okay,
Right.
okay. Colleagues, any questions for Michael? Please, sir. Councilman Rivera.
Yeah, first I want to applaud you for bringing this forward. I've been a supporter of having sponsorship opportunities in parks. It's critically needed to help, as you stated, all the organizations and the teams and help raise money for uniforms and all the other things that would be impacted if we didn't have it. So with that, though, how do you see the guidelines moving forward in the process that if we were to adopt what we've got now, what would you suggest? Because you'd get wrapped up into that as well.
Well, I know in the city planning has got some amendments that they want to show you, but I think with what's being proposed, we're completely fine with, because I think what's important for everybody to understand in our conversations with both the city attorney and planning, we all agree that these are not billboards. This is not. We all agree that this was not the intent of the sign ordinance, and therefore there is no conflict. I think where we started to get a little sideways in the conversation is where specifically mentioning the department and things like that. We wanted to make sure that there's a distinction between what we're talking about, which is what I showed you, but if we do these guidelines, there should not be any conflict with the sign ordinance, because there would be no reason for Rec and Parks to apply for a sign district, because we're not going to do commercial advertising in the parks. We want to be able to recognize our donors and our sponsors.
Do you have a description of or a definition of commercial advertising? Because a lot of what you've shown could be perceived as, if you've got a logo or if you've got one of these examples that you've shown on the slide, could be perceived as commercial advertising.
It could be, and I think what we all I don't have a definition for you, but what we do, we need to integrate into this process a kind of thank you process for thanking them for what they did in that talk.
So if you had some pre-approved artwork, for example, where it was a frame or something that they would insert their ad, if you will, or their sponsorship
That's right.
in, that said proud to sponsor, thank you on the bottom, kind of thing, and they could pick from existing artwork that would then be framed, something like that would have those kind of guidelines that automatically then would be approved. Okay.
That's right, and that's what our guidelines need to address.
I would certainly support that.
Yeah.
Great, thank you.
I think one of the, of course, could be subjective depending on who's listening, but for the most part, the department and the commission is primary duty is protect the parks, to build up the parks, to make them more accessible to people. And under those broad themes, I'm hoping that the criteria set by the signage as described by my colleague will reinforce that sense of purpose and how you manage your facilities and work with the commission. Councilman, anything else? Okay, so thank you for that presentation.
Thank you.
Next, I'd like to ask the planning department to present, and then we'll go to public comment. Please introduce yourself, sir.
Good afternoon, members of the committee. Alan Bell, planning department staff. What I'll do is just provide just a very brief, high-level overview of the ordinance, and then talk about some of the comments that we received at the end of the comment period specified by this committee. So in a nutshell, what does this ordinance do? It limits new sign districts very significantly from what can be allowed today to basically what we are calling regional hubs of commerce and transport. As a condition of a new sign district, there are community benefits in the form of sign reduction or other kinds of community benefits that would improve the aesthetics in the area. Enforcement was one of the biggest issues that the Plum Committee asked the department to address. Enshrined within this ordinance are very significant administrative civil penalties to deter a lack of enforcement, a lack of compliance with the city's sign regulations. For the first time, this ordinance provides very specific regulations for new types of digital signage, and then embedded throughout the entire sign ordinance are numerous technical refinements to include its clarity, its enforceability, and its legal defensibility. This map gets at the heart of the sign ordinance. This shows all of the areas in the city that today that are zoned commercial or industrial and that are eligible to file an application for a sign district. So basically, this is all commercial and industrial zoning within the entire city. In addition, the sign regulations today allow any area of the city to have an exception from the ban through a specific plan. So in essence, the entire city could be designated a sign district. And one of the purposes of this new ordinance is to make sure that we don't have a regulatory framework that would allow the exception to literally swallow the rule. So the ordinance limits the areas that would be eligible to even file and be considered for a sign district to downtown and to regional centers and then regionally zoned commercial areas. So this shows a comparison between, under this ordinance today, what could be eligible as applications for sign districts. This does include the Port of Los Angeles, and it also includes the airport, LAX. So it's essentially a 90% reduction in the acreage that could be eligible to file for a sign district under the proposed ordinance. We did receive numerous comments based upon the last draft. There were 7 new letters that were received since our draft was released in December. Most of the requested changes are very minor in nature, or they are recycling comments that have already been made in previous iterations of the draft sign ordinance. So in essence, there is nothing that we would propose that would be substantive recommendations or substantive changes to the draft that is before you today based upon those comments. There were a few minor technical corrections that we read into the record at the last hearing. These are just listed so as a recap of those that were already heard by the committee, and that had to do with the definition of window signs, allowing temporary signs on temporary construction walls under the residential accessory services zones. That is, again, just an update that allows the RAS zone, which is essentially, it's a mixed-use zone. And then there are different updated references to the grandfathering list. Those are pending sign district applications. So I think the 3 main substantive topics for discussion today, and we've already had some presentations on those already, are the digital displays and the court ruling in the Summit Media case and Councilman Krikorian's letter. The off-site signs in parks, which has already been addressed by Recreation and Parks, and then also some constitutional questions relative to administrative civil penalties. So I would imagine that most of the public comment will address these 3 main topical areas. And then finally, I just wanted to present to the committee this map of all of the billboards that are currently within the city of Los Angeles. And we tabulated each of these billboards by council district. There are close to 6,000 billboards in the Building and Safety Database throughout the city of Los Angeles. They are fairly evenly distributed throughout all of the different council districts. The council district with the most billboards, according to this database, is Councilman Weezar's district, with the most at 616 billboards, and the council district with the least number of billboards is Councilman Englander's district with 156 billboards. So there is a range of billboards. And Councilman Reyes, 419 billboards in Councilman Reyes's district. So what I think this map shows are the opportunities for sign reduction, which is embedded within the ordinance, and there are opportunities for further sign reduction, I think, based upon this inventory. So that concludes my staff recommendations. We are going to have also just a more formal recitation of what we would propose to be the instructions that the committee could adopt. So Daisy Moe, on Planning Department staff, will read those into the record.
And before you start, I just want to say thank you to you. I know you've been doing a lot of the heavy lifting throughout these years and behind the scenes kind of person, but I appreciate your hard work and your diligence in getting us to this point.
Thank you.
Thank you.
So Daisy Moe, Planning Department, reading the department's recommended final instructions from Plum to us for the sign ordinance. The first is to adopt the Department of City Planning's report and proposed ordinance dated December 4th, 2012, with the following changes. To amend the definition of window sign in section 14.4.2 to remove the proposed language previously proposed at the last hearing. Amend section 14.416E to add RAS zones to the zones where temporary signs may be displayed on temporary construction walls. Amend section 13, the grandfathering provisions, to update the paragraph references to reflect the recent renumbering of section 1311. And make the following changes to clarify the regulations involving signs in city parks and public facilities. First, to amend section 1311, C1, to remove the PF zone from the zones eligible to apply for a Tier 1 sign district. Amend section 1311D to state that each Tier 2 sign district shall not include properties that are zoned OS or PF. And to delete section 14.440, off-site signs in city parks and facilities, since that section would no longer be needed. One additional minor tweak, just to clarify, to amend section 14.4.4F3 to specify that brightness testing should be done by the Department of Building Safety or by a testing agency approved by the Department of Building and Safety. The next instruction that we recommend would be to instruct the city attorney to review the proposed ordinance for form and legality. The next instruction recommended would be, as recommended by Councilmember Krikorian, to instruct the Department of City Planning to work with the CLA and the Office of the City Attorney to convene a working group representing the range of perspectives on off-site and digital signage, to hold a limited but sufficient number of meetings to consider a potential program for allowance of digital displays in exchange for substantial reduction in non-digital off-site signage, and also provision of community benefits and possibly revenue sharing with the city, pending the resolution of court deliberations on this matter. Following these meetings, the Planning Department is further instructed to report back to Plum with recommendations on next steps. That would be our recommendation. And two more things on this long list. To note that updates have been made to the list of grandfathered projects, and to further note that two additional proposals of further refinement of two provisions on brightness limits for non-digital signage and projection of architectural ledge signs may be submitted by the appropriate stakeholder groups within 30 days to the Department of City Planning.
Okay. The working group will have this ordinance as a draft to work with as they meet. Is that be accurate?
Well, the idea would be for the working group to move on a separate track than the ordinance, so to have a separate ordinance addressing digital signs.
Okay. Okay. All right. Any questions for our staff? Yes, Councilman.
You spoke on the illumination issues, and I was just reading this letter here from the ISA, and these are the issues, some of these issues that will be addressed, that'll come out and then come back in terms of suggestions, because it appears that by some of the suggestions or issues that they had, they couldn't comply with some of these concerns. So what's your time frame on addressing some of the illumination issues on the non-digital?
It would be 30 days. We did meet with representatives from the sign industry, and we did review that particular letter. There's a concern that brightness limitations that we are proposing for digital signs may not be appropriate for static displays. So the industry is currently researching this. They have not forwarded any specific recommendations to the department. They have not forwarded any specific changes to those regulations. They are asking for more time to research this. The issue may have merit, so we would propose that the committee impose a time limit of 30 days to submit it to the department, and then if we think it has merit, that we would come back to the committee and present those recommendations. But again, the sign industry has not proposed anything specific.
Well, and let me just, if I could, just to create the dialogue there, because I think the concern has merit. It says most traditionally illuminated signs don't have the ability to automatically adjust with ambient light. I would think that would be true.
That is correct.
That there hasn't been historically overly bright traditional. This is really set aside from the digital concerns. Whether the industry has, if they have suggestions, that I would ask that they come back here no matter what, if we could, just to hear them, to put that to bed. We've got to address that at some point, figure that out. You're saying it would come back here only if we felt it had
No, we
merit?
believe that we should come back.
Okay.
I mean, I think we should keep the dialogue open and keep the conversation going.
What would we do in the meantime?
Well, we would continue to meet with them, but I think it's up to the sign industry to propose something specific. So I agree that the issue has merit, but as far as the automatic sensors, we are not recommending automatic sensing for static displays. That is only for digital displays that would have the automatic sensor. So that standard has never been recommended for static displays. So
there may be some confusion there.
So the question is, should there be a different measurement metric? We have foot candles as the measurement metric. There may be an idea that a different measurement technique called nits might be an appropriate measure, or whether or not static displays should be allowed to be brighter than digital displays. But I think we would need more information to be able to conclude that in fact is the case.
Okay. Any other questions?
Does that answer your question?
Thank you, sir. Okay, let's go into the public comment period, and I'll be asking the following to please come to the microphone. When you do come to the microphone, give us your name and address. If you wrote a very articulate letter, you've got 2 minutes. If you can get to the main point of your letter, that'll be to everyone's advantage. And okay. And so, let's begin. We'll have with us Barbara Broyd, then Lucinda Sterrett, and then Phil Reck. Good afternoon.
Good afternoon. Thank you, Chairman Reyes. I'm Barbara Brody, Westwood South of Santa Monica Boulevard homeowners, West Side Neighborhood Council and Coalition to ban Billboard Blight. I appreciate the proposed action to move this ordinance forward today with no further revisions. We're very concerned that perhaps an effort would be made to undermine the current Summit Court Appeals process, which we strongly support. I want to throw in one unplanned comment having to do with parks. In our park near us, there was a super graphic sign that is not a billboard that was larger than 2 or 3 billboards in height. So it's a little more complicated than it may appear to be, and I hope that the committee and that the staff looking at this will look at that. I wanted to bring you a present today. I brought you something for Christmas last time. I have the ribbons, but the printer was not cooperating, to give you a new study that was done in Australia. 2 studies have surfaced in the last month, both dealing with digital sign safety and traffic safety. And they're important studies because we're dealing with a brand new technology. Hasn't been around long. We have on the one side an industry that says, hey guys, everything's fine. They're no more dangerous than conventional signs. But we also have our personal experience, which is seeing how they distract drivers, seeing the cues at left turn lanes where there are multiple signs posted, be delayed, and this warrants the council's attention as we move forward. It is government's role to protect the safety of its citizenry, and we're very concerned that these signs do endanger drivers and pedestrians and people on the street. I invite you to come to a couple of intersections near our home, where we have 3 digital signs in one intersection and another sign in which the traffic signal actually disappears. When the light is red and the digital sign is red, you can't see them. You cannot see the signal. So we hope this does not, that digital signs don't expose the city to litigation because of these newly documented safety concerns, but we hope the city attorney will work with the council in looking at potential liability.
Thank you.
Thank you.
Thank you very much. Lucinda Sterrett, then Phil Reck.
Good morning, council members, and I'm going to submit a document.
Good afternoon.
Good afternoon. I'm Cindy Sterrett from Latham and Watkins on behalf of Clear Channel Outdoor, and what I've submitted to you is some suggested language from the LA Outdoor Advertising Coalition, which also includes CBS Outdoor and Lamar Advertising. Those companies represent about 90% of the off-site sign structures in the city. And we'd like to ask that the committee direct the city attorney and planning staff to continue to look at the policy issue of due process in the enforcement provisions that are in the current ordinance. These provisions really date back to 2008 and 2009 when the committee first started reviewing these issues. Since that time, the city attorney's office has done a great job on enforcement. Many enforcement actions have been successful. We have hundreds of thousands of dollars paid to building and safety for inspections. Only 7 signs of 9,000 faces are shown to be in violation under building and safety's principles, and yet the enforcement language that's in the ordinance before you still says the city has no tools for enforcement, and it suggests that a property owner could be subject to $48,000 a day for any violation of any sign ordinance, not limited to this new ordinance. I believe that could apply, for example, to the mural ordinance. Any alleged sign violation up to $48,000 a day. We've talked with the city attorney's office and planning. They indicated they need policy direction from this committee to continue to look at these issues and consider whether this language should be tweaked further during the process of the form and legality review. And we're asking that that happen. They suggested that there be a burden to show some evidence of a permit, some evidence of a lease in order to get tolling. We've suggested language to accomplish that. We don't want to delay the process, but we ask for that opportunity as the city attorney reviews the final form of the ordinance.
I'll have a comment on that once we go through public comment and
Thank you.
hear from everyone. Phil Reck.
Good afternoon. Phil Reck of the Mayor Brown firm. We represent Summit Media, which, as you know, is the company that brought the lawsuit invalidating the settlement agreements and the permits that allowed 100+ illegal digital signs to go up by CBS and Clear Channel. We heard the proposal today for a working group. Clearly, it's much more promising than some other suggestions which have been aimed at grandfathering in the illegal digital signs. But let me just suggest the devil is in the detail. Each component part that's suggested, a limit on a number of signs, where they should go, a process under which they'd be allowed, each of those has enormous complexity. And how each of those issues is resolved will determine in the end if the proposal is fair and balanced and legal holding up in court. As such, we'd suggest it's important that the working group in fact be fair and balanced in its representation, that its meetings be held in public, that any proposal that's developed go through the full and complete vetting process, including CEQA review, Planning Commission review, full hearings before this committee, and that it not be done on a rushed or hasty basis. Finally, and most importantly, though, is that no proposal should issue until that court ruling is final so that everybody knows exactly what the legal requirements are, and certainly no proposal should be approved until the 100 digital signs are shut down. And the reason is that it is impossible to develop a new policy on digital signs that is going to be fair and balanced and holds up in court unless and until there's a level playing field. And there can be no level playing field until these 100 digital signs come down. So when that ruling becomes final, we urge Plum and the City Council to promptly force the removal of the illegal signs, and let me just suggest large penalties in the new proposal might be helpful in that regard. Then and only then, when those signs are down, can the goals of the working group be achieved. Thank you very much.
Thank you, sir. Wendy Rosen, Richard Spicer, and then Lane Lawson. Good afternoon.
Good afternoon. My name is Wendy Rosen, and I'm representing Brentwood Residents Coalition 491103, Los Angeles 90049. I want to start by just thanking everyone. I mean, I think this is my 9th hearing on this ordinance, and it has been an exhaustive process. We've worked hard. Planning department has been amazing, city attorney, and you've heard a lot from the community. Having said that, and we think that, you know, although not perfect, this is an ordinance that should move forward as our council member represented today on our behalf. There are some things that I think are important to state. No matter where you live, you can understand that if a digital sign that changes every 8 seconds is facing or shining into your home, it is going to impact you. And there have been news reports that I'm sure you've seen, the articles, that people are suffering from these digital billboards and the images moving and the light impact. So I think that that's something that really needs to be considered, and I agree that they should be shut down. And I don't know if it's been stated today, but the appellate court did refuse rehearing on the Summit matter. So that is now a final issue with regard to the appellate court. Mr. Englander walked out, and I know he can hear back there, so this is really addressed to him. But in our district, we have static signs that are lit, that are impactful. The technology is such with lighting these days that those signs are being lit in such a way, they're facing down into the communities, they're very bright. So I do think this issue about the difference of the measurements is important, but I don't think we should underestimate that static billboards can be any less impactful than digital billboards depending on how they're lit because of the technology. I would just ask again that this move forward before many of you are either termed out or this issue doesn't get resolved. Thank you.
Still got 5 months. I'm sorry. Thank you. All right, come on up. Give us your name, please.
Good afternoon, members of the committee. Thank you for your work on this, and to the staff who've been very cooperative in keeping in touch with neighborhood councils. My name is Richard Spicer. I'm representing the Greater Griffith Park Neighborhood Council. I live at 4002 Holly Knoll Drive, Los Angeles 90027. You have from us a community impact statement. It is based upon a lengthy letter that came to you September 26, 2011. All those points are still relevant. We support some matters, we do not support others. We do not support off-site signs in parks, we're thinking Griffith Park, nor in the zoo. So there's great concern about this new version appears to allow off-site signs in zoos. We are opposed to digital signs in general, and what we have today doesn't seem to add too much. And the earlier speaker today, who cited 3 signs and it blinds out a street signal, that raises additional concerns. The parts we do support, our regional is a sign unit, but from what we read in the ordinance, we do not see the funding for that unit. Critical to have that funding. Also, in the advisory committee, concur in the earlier comment, it's a very desirable element to have, and it should include community representatives. 2 minutes? I'm not used to 2 minutes. It's usually 1 minute. Thank you.
Okay. Well, sometimes less is more. Okay, you got 10 seconds.
I thank you for your opportunity to speak to this, and I'd appreciate it if you would take a look at the community impact statement. Thank you very much.
All right. Thank you, sir.
Thank you, Chairman Reyes. Committee members, my name is Lane Lawson. I'm the Director of Public Affairs for Clear Channel Outdoor, Southern California Division. We appreciate the long dialogue that we've had with staff and many hearings here in your committee. However, as stated before, there are some issues that are still needed some attention. On the enforcement section of the proposed ordinance, we have supported the city's efforts in the Billboard study, or their Billboard survey, 100%. We paid several hundred thousands of dollars in inspection fees, and the city has done a great job on those inspections. We ask that the language in the ordinance on enforcement continue to provide a fair process where facts can be researched and appeals are possible. We hope you will direct staff and the city attorney to continue ongoing discussions and address extreme fines of up to $48,000 a day that impact our landlords, most of which are small property owners. Secondly, we still need a legislative option for digital billboards, legislation that will provide sign reduction, quality of life standards, and public benefits to the city and to the communities. We're eager to move forward with those discussions. As our company has done for the past century, Clear Channel Outdoor remains committed to the community we serve. We appreciate the opportunity to work with the local government to find a solution that benefits the local economy, businesses, and the community groups. Thank you.
Thank you, sir. Next group of speakers, Dennis Hathaway, Barry Johnson, and Ryan Brooks. Please come on up. Good afternoon, sir.
Good afternoon. I'm Dennis Hathaway, president of the Coalition to Ban Billboard Blight. I want to comment on one of an earlier comment that was made about enforcement. But first I want to say that we consider the enforcement, the penalties, administrative penalties, extremely important in this ordinance. And it is one of the major reasons that we want this ordinance passed, so we're supporting passage of this ordinance right now. Just in the last month, I have personally photographed and seen, just in a fairly small area, 3 big illegal super graphic signs. These are people putting these signs up, apparently with the idea that the profits are so big or so large that they'll take a chance and try to get by with it. So these penalties could provide a real deterrent. The comment made by the speaker was that the inventory showed only 7 illegal signs. In fact, we've been through the inventory with basically a fine-tooth comb. There are over 1,300 billboards out of the 5,784 structures with 9,000 faces. Over 1,300 were either put up without there are no permits on record, or that they were altered without permits. Most commonly with a second face added, or being enlarged, made wider or higher. And the reason that they are not, and the billboard companies are standing on a state law that I'm sure that Mr. Fong could explain very much better than I can, that directly impacts the situation, a state law that's called the rebuttable presumption of legality. So that's what the issue is there. There's no question that there are a lot of billboards out there that are either unpermitted or illegally altered. Thank you.
Thank you, sir. Good afternoon.
Hi. Barry Johnson, Studio City Neighborhood Council Government Affairs Committee Vice Chair. And I've been appointed by our President, John Walker, to read a motion that was passed only 6 days ago, and I provided copies for you this afternoon. The board of the Studio City Neighborhood Council urges the City of Los Angeles to fully implement the appeals court ruling in the Summit Media LLC versus City of Los Angeles, and to remove the 100-plus digital billboards as provided for therein. We further request that the city refrain from making any changes to the zoning laws relative to digital billboards until any such proposed change has been subjected to an open and transparent outreach to the communities and to the neighborhood councils in particular. We also request that the previously drafted sign ordinance being considered by the Planning and Land Use Management Committee and the City Council be considered as it is currently written, and that no language be added to that ordinance which would retroactively legalize the digital billboards which were the subject of the appellate court decision, or in any other way incorporate digital billboards into the ordinance. This motion shall be added as a community impact statement. Thank you.
Thank you, sir. Our next speaker, Mr. Brooks.
Good afternoon, council members. Ryan Brooks with CBS Outdoor. Mr. Chairman, members of the council, thank you for giving me this opportunity and time to speak. I want to echo some of the comments that were heard today on enforcement. While CBS Outdoor is one of the reputable companies out there, we actually believe in strong enforcement. It's a good tool to use. You know, we're a for-profit company, and it's supply and demand. So when the illegal billboards go down, it's good for our shareholders, it's good for our company. The challenge is having fines of $48,000 a day is a little overkill in our opinion. One of the challenges is the city never had a comprehensive sign code until 1986. Many of our signs have been up since the 40s and 50s and 60s. And so we understand that there can be disagreements by two people looking at a permit, in two different ways. The challenge is we have a fine of $48,000 a day. The process for the city could take 6 months, 12 months, or even a year to get adjudicated while those penalties and fees keep stacking up. We've gone to various hearings where someone goes on vacation, 4 more days gets added. And so the challenge is, with the process that's set up. What we're advocating, I think, is a fair process, and a process that most cities have around the nation. If there's a disagreement between two parties, either a billboard company and the city, it's very simple. You get a notice to comply. The city says, provide us with information. They take a look at that information, and at that point in time, if there's still a disagreement, then you can have penalties. Until that process happens, there's a due process challenge with that. There's a fairness challenge with that, and I don't think this billboard industry should be singled out. There is no other fines in the city code right now that has penalties of $48,000 a day, and I do believe that due process should happen. You're innocent until proven guilty. All we're asking is for the time for both parties to sit down, adjudicate the issue, to show the paperwork, and if there's still a dispute, then penalties could start. Thank you very much for your time. I appreciate it. Thank you.
Thank you, sir. Okay, our next group of speakers, James Carpenter, Theresa Marcus, and Ray Baker. He's coming up.
Hello, James Carpenter here on behalf of the California Sign Association and the International Sign Association. And first, I just wanted to really appreciate all the time and effort that staff has put into this enormous work. And it's just taken a long time, and we know what it takes to get this done. And what I wanted to mention, and you've got a letter that outlines all the details. I'm not going to go into the depth of what the letter gives you, but I just wanted to just briefly mention the concerns that we have in relation to the illumination levels for the non-digital or traditional signs. And the first one is the proposed standard really has no scientific basis. We don't have any studies that really back that up, and that's our main concern. And the proposed approach really is not technically feasible. And then and we also think that a number of existing traditional signs may not comply with this standard, and there could be an impact that's really not expected or understood at this time either. So just based on that, we're really in full agreement with the suggestion from Alan and Daisy in relation to the instructions that ISA, International Sign Association, and the California Sign Association work with staff and come into agreement and come up with a standard that will work for the city, work for the industry, and work for the business community too. So we're in full agreement with that, and we anticipate getting that done within the time frame suggested.
Thank you, sir.
Thank you.
Thank you very much. Good afternoon.
Good afternoon. Can you hear me? Good afternoon. My name is Theresa Marcus. I'm from Boyle Heights. I live at 3122 East 3rd Street. And I'm president of the Boyle Heights Stakeholder Association, which I present today. But I'm affiliated with the Boyle Heights Neighborhood Council Planning and Land Use Chair. I'm the chair for that. And Mothers of East LA, Resurrection Church, Neighborhood Watch, and so on. But our biggest concern is the advertisement of alcohol in public property. But another big concern is that we're against this digital billboards. And for them to come into the city is going to be like a Vegas all over again. And Councilman Weezer, our district of 666 billboards, and I know they're not all in Boyle Heights, but the ones that are on Boyle Heights are advertising alcohol all over, especially on Lorena. And we're trying to keep away alcohol from the children, from the youth, students that have caused also dropout and low grading. So we ask you to really consider the children and the students that are looking at these billboards and the blight they create. There's a lot of blight in Boyle Heights that you look across and the billboards are just covering everything else that's in the way. The digital billboards, please, just drive through the 5 freeway at City of Commerce and you will see the dangerous that those billboards are causing. I pass through it and there's always accidents because of the billboards.
Thank you, ma'am.
Thank you very much.
Thank you. Ray Baker? Is Ray Baker here? Okay. Patrice Williams? Donald G. Keller? Good afternoon, ma'am.
My name's Patrice Williams, and I'm the founder of the Minorities in Broadcasting Training Program and also the Going Green Film Festival. And I'm here today to tell you a little bit about us and why we think the billboards are important to the nonprofit community. Los Angeles is like the #1 entertainment industry in the world, and they employ countless people and jobs, and people come in from around the world, not just from other states, to seek employment in the entertainment industry. And these billboards are highly effective in providing an outreach to this business community and for the nonprofits as well. You can go down La Brea and you'll see that there are ads now for the movies that are out that are, because it's award season, and they're promoting their films, and it's in order to get more people into the theater, more seats and seats filled in the theater, and that's important if we want a healthy, economic community. I believe that these electronic billboards are cutting edge and sustainable, and that's important to me as a filmmaker myself, and also to someone who's created an organization to try to cut down on waste in Los Angeles. And so this is something that we've looked to as a resource for us that we consider innovative and sustainable. If the ordinance before you today goes into effect without consideration, I believe that it'll have a negative impact on the industry. Film LA, which is the nonprofit organization that issues permits to the television and film industry, they just released a report this month that said that film production in Los Angeles is up 4.7% over last year. However, they still consider it dire, and that's not my words, those are theirs.
Thank you very much.
Okay, so I just believe the exodus will continue if you don't look into the ordinance and tweak it a little bit.
Thank you, ma'am.
Thank you.
Okay, next speaker coming up, give us your name. It's Ralph Hawk.
My name is Donald G. Keller. I live in Brentwood for 54 years at my home at 808 North Kent Avenue, and I first came to Brentwood in 1948. Honorable Council members, digital billboard signs are hazardous and unsafe. At an intersection equipped with traffic signals, the lead driver is so entranced by the digital display across the street that he's not aware the light has turned green. As a result of the queue of vehicles behind the entranced driver begin to sound their horns to get things moving. Count the frequency of the traffic signal changes in 24 hours, and you will understand that the horn honking is an invasion of the right to peace and quiet expected by the residential occupants near the intersection. Then, when there is no queue, a driver approaching the intersection who sees the light is green hits the entranced driver watching the billboard, causing a rear-end collision with all the vehicle damage, whiplash, medical injuries that attaches to the existence of these digital displays. The constant flashing, dimming on off of the display at night is nerve-wracking to the nearby residents, causing undue and excessive stress. These displays are an invasion of our right to quiet, peaceful lifestyle. Please make them illegal and shut them down. Thank you.
Thank you, sir. Okay, Ralph Hopp, Stephen Resnick, please come on up.
Good afternoon, Chairman, members. My name is Ralph Hopp. I'm here on behalf of Granada Hills Rotary. And just wanted to point out that CBS Outdoors has partnered with us for years in our annual blood drive, which we believe is the largest in the San Fernando Valley. Without this advertising, it would be very difficult for us to get the word out, to be able to get as much blood as we have. We usually get about 400 pints. We've done about 1,400 pints total in this last several years, which totals about $450,000 worth of blood that we've raised. City of Hope is also able to come there with their bone marrow registry to be able to get people registered for bone marrow. CBS Outdoor in the industry provides us free advertising, donating millions of dollars to charities like us every year that do not have a budget and would be very limited on what we could do and market to raise awareness in the community of our events. I want to thank you for having me here today. I hope on behalf of Granada Hills Rotary and all the members here that you guys can come up with an equitable and fair conclusion to your discussion here. Thank you.
Thank you, sir. Stephen Resnick, then Veronica Perez.
Good afternoon, council members. Stephen Resnick, President of the Westwood Homeowners Association and Secretary of the Westwood Neighborhood Council. Chairman Reyes, thank you and your council members for all the work you've put in and for the planning department. It's obvious how much work you've put in all the hearings you've held. We feel that the time is right. We felt so earlier that you have a solid ordinance and it's time to pass it. And we echo the comments of it was a pleasure to see Councilmember Rosendahl here earlier. And Councilmember Krikorian, and with the ordinance, we ask that you pass it. Additionally, I would call your attention to the agenda and suggest that all the neighborhood councils that are listed as against it are perhaps, I can't speak for them all, of course, but circumstances may have changed with the ordinance you have, and their outlook on this may have changed also, as you probably know. I would also say with regard to digital billboards to echo the comments of the Summit Attorney, Mr. Recht, on the digital billboards, and it's been my experience in following this. There is no question that when you have a rainy day, a wet street, a white bright digital billboard that you're staring at, it's a dangerous situation, and there's been testimony to that before, and we hope you note that. Thank you very much.
Thank you, sir. Good afternoon.
Good afternoon, council members. It's Veronica Perez from Holland and Knight, representing CBS Outdoor. We share the city's goal of disincentivizing illegal signage. However, the proposed penalty schedule before you is draconian and unnecessary. A lot has changed since 2008. First, as you know, the city adopted an ICO banning super graphics, which it later codified into law. Secondly, the city enacted an off-site inspection program into which members of the LA Outdoor Advertising Coalition have paid in hundreds of thousands of dollars in inspection fees. A recent building and safety survey, as published on the KCET website, showed that out of 9,000 billboards in the city, only 7 were identified as illegal. These are not our numbers. This was a building and safety survey, the department that is in charge of enforcement in the city. Finally, I think we all recognize that the city attorney has done a great job of enforcement. Illegal super graphics are down. And the city accomplished all of this without imposing these draconian penalties that we believe violate First Amendment and due process rights. We question how the city can make the finding that it cannot enforce the sign regulations without this penalty structure when it's been enforcing with great success over the last several years. We ask that you work with us to create a fair penalty structure, and we thank you for your consideration.
Thank you. Marion Dodge and Lisa Gritzner. Marion Dodge. Good afternoon.
Good afternoon, council members. I'm Marion Dodge, representing the Federation of Hillside and Canyon Associations, as well as Friends of Griffith Park. The Federation has voiced its opinion on the sign ordinance many times, and we reiterate that position. The ordinance must limit off-site signage to designated sign districts in regional commercial areas. The ordinance must prohibit commercial advertising of any kind in city parks. We understand they said they don't want billboards. Billboard is only one type of advertising. There are many different types of advertising that need to be addressed. The ordinance must require that new off-site signage and sign districts be offset by the removal of billboards in surrounding communities. The ordinance must include penalties significant enough to deter sign companies from violating the ordinance. And Friends of Griffith Park would be happy to work with the Department of Recreation and Parks on a donor recognition program. We urge Plum to go ahead and move this ordinance forward. Thank you very much.
Thank you. Lisa Gritzner.
Good afternoon. Thank you very much. Lisa Gritzner, representing Van Wagner Outdoor. You've heard a lot of folks here today, and I just wanted to echo a few of the comments. One is obviously the digital issue is something that has yet to be resolved, and we agree very wholeheartedly with the community members and with the representative of Summit Media here that the city does need to take a long look at this. We very much would like to participate in the working group that is being proposed. You have heard from the Los Angeles Outdoor Advertising Coalition, of which Van Wagner is not a member, and so we want to make sure that any industry representation takes into consideration those entities like Summit and Van Wagner that are not a part of the settlement agreements, not a part of some of the policy issues that are being promoted by the Outdoor Advertising Coalition that exists. Also, I think it is very important to remember that as Mr. Rex stated, that any addressing of the digital issue does have to take into consideration the necessity of a level playing field, allowing folks who have an upper hand in the marketplace with over 100 digital billboards that were granted exclusively by the City of Los Angeles. They have a monopoly on the marketplace today, and we believe that in order to address this, we do need to level the playing field for other companies who chose not to sue the city to be equally represented. And then the only other thing I will add in my last 39 seconds is that the swap provisions that exist where there's a takedown provision in the current ordinance definitely does not reward people who have been good actors, who don't have a lot of inventory, who don't have any illegal inventory, like Van Wagner, and we would urge that at some point, whether it's today or in the future, that we consider the ability to let community benefits and let community input for things that matter in the community, like perhaps cleaning up graffiti or providing beautification programs in a community, be something that can qualify as people are looking to new signs. Thank you very much for all of your hard work and for the opportunity to speak.
Thank you. Mark Stratton and Doug Arsenal. Good afternoon, sir.
Good afternoon. Mark Stratton, Basboa. I would just like to support Bill Rosenthal's position that the motion needs to go, the ordinance needs to go forward without any changes. And I'd just like to address that as a film professor at USC, the notion that digital billboards is somehow going to stop the migration of jobs from LA is just pure nonsense. These the billboards, the digital billboards are quite distracting, and films and such things need to be placed in a environment which is not distracting in order to be fully appreciated. Thank you.
Thank you, Doug Arsenal. Then we have Louis Becker.
Good afternoon, council members. My name is Doug Arsenault of the Valley Industry and Commerce Association, representing more than 380 businesses in the city that rely on signage, including members of the entertainment industry, local small businesses, consumer good manufacturers, and retailers. VICA wishes to thank the Planning Department for undergoing this seemingly insurmountable process and their willingness to work with the business community to find mutually beneficial solutions. However, we remain concerned about the enforcement section of the proposed ordinance. The city has acknowledged on numerous occasions that its permit records are incomplete and missing many issued permits. Yet the fine structure punishes businesses that may not even know that their sign is illegal. While we understand that fines must be assessed at a value that will incite change, the proposed daily penalties of between $2,500 and $48,000 are unnecessarily punitive. These provisions do not provide any mechanism for staying the accrual of penalties during a good faith appeal in which the legal and factual issues raised by the compliance order are addressed. We ask that the proposed enforcement language be revised so that they do not wipe out small businesses before the actual and legal issues involved in the challenge are decided. Beyond the policies contained within this existing draft ordinance, we encourage the city to move forward as soon as possible with establishing standards for current and future digital signage as directed by the entire council in October. We encourage city leaders and staff to explore a legislative solution that will provide clarity for the outdoor advertising industry and ensure this marketing option is available to local businesses. Thank you.
Thank you, sir. Lois Becker, then we'll have Mort Allen. Good afternoon, ma'am.
Good afternoon. Lois Becker, Bel Air Skycrest Property Owners Association. Like communities across Los Angeles, we support the request of our council member Bill Rosendahl and the Coalition to Ban Billboard Blight and the Hillside Federation to move this ordinance forward today as written and to deal with any outstanding issues in a separate and fully transparent process. We support stiff penalties as a deterrent. If people intend to follow the law, and by people I mean corporations, why are they so concerned about penalties? We agree with the remarks about the need for a level playing field. In regard to the parks issues, we share concerns about the definition of commercial advertising. Any proposals regarding park signage and digital signage being legalized should be dealt with on separate tracks through a full, open, and transparent process. Thank you for all your work.
Thank you, ma'am. Mort Allen? Good afternoon, sir.
Mort Allen, Studio City. Where were you 14 years ago? 14 years ago, we set up the sign task force in City Council.
Yep.
Hal Burnson set it up. I was the head of it. Ken Spiker was on it, a few other people. And we had everything pretty well arranged. And then a city councilman that was then in CD5 got it disbanded. It was the one prior to Jack Weiss. I don't want to mention his name. But that's when they put up 500 illegal billboards in the 5th District. And this whole thing is the 5th District. I mean, you don't have any in your district. It's all around that one area of all the rich homes. And right now, and let me just tell you something. With the sale of AEG, the City Council gave them all those billboards for free. Those are appraised at $2 billion in the sale price of $10 billion for AEG. So that was $2 billion, and the city's not getting the normal 20% like they get on other things, like at the airport when a lease is sold. So there's so much dollars on this. Each digital billboard brings in approximately $2.5 million a year. Now, you add 130, I believe there are right now. Isn't that it? 108 and 20 or something? Digitals, okay. But that ordinance that also was overturned in the court also had to do with putting the second side on the billboards and making them larger. You haven't looked at that. So to me, the only question is this. The city passed an ordinance in 1972 allowing billboards on public properties, and the city was leasing them out. We have so many buildings. You take Piper Center, you could probably get $1 million a month on billboards on the sides of that building. So what you got to look at, number one, these buildings have been deemed illegal. Why aren't they paying the city 20%, 30%? Out in the desert, the Indians get 70% of the revenue on their billboard leases. City Ranch Mirage gets 50% of the billboard leases. And we're just not getting any money, and we're so broke. So I think it's all about dollars and nothing
Mr. Allen,
else.
I'm just curious. When you brought forth those large dollar figures,
yeah,
where do you base that from?
Research from Jane and a few other people up in the office. Right now the average I think is 100,000 Pardon me?
Which Jane and which office?
Up in Mitch's office. I can get the figures for you. I know that the average is 200,000 a month.
I'd like to see that study. But thank you, sir.
Okay, great. And one last thing, we should ask the billboard companies all to do a public service and put up messages for everybody to vote next month.
Thank you. Nancy Friedman, please come on up. Kathy Wright. Leanne Muller.
Hi, Nancy Friedman, Homewood Road, Brentwood.
Good afternoon.
Oh, okay. Gentlemen, respectfully, I come before you concerning the billboard ordinance that was poised to be sent to City Council in December, and I hope you will hear me out. I realize that those of us speaking as citizens of Los Angeles are heard less by your ears than that of the lobbyists. I don't begrudge their well-paid work, as they are otherwise good people who also are blinded by these billboards when at the end of the day they take off their lawyering hat and go home to their respective communities. It is a job. I realize that your job is to find money. You okay? Your job is to find money to balance the city budget, but a bad deal was made, and therefore honorably obey the laws of the court and take the right and moral step by going forward. It seems that money speaks louder than the quality of life of the people for whom you were elected and for whom you are supposed to be working. Prove us wrong. There is no evidence that you are serving the people of Los Angeles by changing the path of this ordinance. I ask that you abide by the decision of 2 courts of law that have determined the billboards to be illegal and removed. Also, penalties are not an issue if the law is followed. Why talk of reducing them? I am grateful to have the right to speak my thoughts in hopes that you will morally act for your constituents and beyond the quest for money. Please send the ordinance as drafted to City Council and find your place in Los Angeles history. Thank you.
Thank you much. Kathy Wright.
Good afternoon. My name is Kathy Wright. My office is at 701 East 3rd Street in the Arts District. And I appreciate the opportunity to be here today on behalf of ArtShare LA. ArtShare LA is a sanctuary for the arts and their creators. We offer our space as an outlet for emotion, reason, vision, and exploration. We speak a common language and share common peace for the arts to flourish here with unique ability to stir, empower, and connect. LA ArtShare has been the recipient of many billboards, both traditional and digital, to use as an outlet for our creative community. The art billboards allowed Angelenos to immerse themselves in the arts while helping the artists reaching a larger audience in an organic way. Keeping the public engaged is crucial to art culture in Los Angeles, and donated outdoor advertising space has played a major role in making art a part of everyday life in Los Angeles. In a time where funding for arts programs at schools, museums, and galleries is on a decline, it's more important than ever to make sure that art remains accessible to the public. ArtShare LA supports the developments of a clear and comprehensive approach to outdoor advertising and citywide guidelines for digital signs. We ask that the committee come back with a resolution in February and March on this issue. We're sincerely concerned that such strict limitations on digital billboards would serve as yet another impediment to the arts community in Los Angeles. Digital billboards are uniquely accessible to the public, and we ask that you consider how this ordinance would affect millions of Angelenos and organizations like ours that rely on this advertising space to reach people all across the city. Thank you.
Thank you, ma'am. Leanne Muller. Then Tina Hussain. Hi there.
Chairman Reyes and members of the committee, thank you for this opportunity to speak with you today. I am Leanne Muller, president of Clear Channel Outdoor of Southern California. And Clear Channel Outdoor has been a proud member of the LA business community for over 100 years. We work with the LA business community, both small and large. And one of our larger advertisers is in fact the entertainment industry. The entertainment industry has embraced the use of digital advertising, as well as traditional, but using digital advertising because of the immediacy that digital provides to promote the film industry. And I think you of all people know the impact of the film industry to this community in terms of jobs and revenue. Like all businesses, we need clarity and consistency to conduct business and appreciate that some changes have been made to this consensus ordinance. However, the issue of enforcement still needs work, and we ask that those discussions continue while the city attorney reviews this ordinance. We also urge quick progress on digital signs and the digital sign portion of the ordinance so that public safety and other business benefits can continue to the city. We are committed as a company to being a part of a productive dialogue. By continuing to seek a legislative solution to address digital signage, the City Council can ensure the continuation of resources that provide valuable public safety information, as well as providing a voice for local business in this community. We again really want to emphasize our commitment to working with this committee, and we thank you for this opportunity to speak.
Thank you, ma'am. Good afternoon.
Good afternoon. My name is Tina Hossein. I'm here on behalf of the Los Angeles Area Chamber of Commerce and our 1,600 member organizations. The LA Chamber supports policies that allows businesses to advertise their goods and services, grow their companies, and boost our economy. As such, we've been following the development of the draft sign ordinance and find that there are certain elements that still need refinement. The draft ordinance would impose penalties up to $48,000 per day on both sign and property owners during good faith appeal periods, which is unfair and risky for business owners. Property owners would have to choose between the steady income associated with a presumptively lawful sign or face drastic fines that could wipe out a small business owner long before legal issues are decided. For on-site signs, we ask that you leave the maximum brightness level for traditionally illuminated signs as is, instead of drastically reducing the allowed levels without justification. Relating to digital signs, which are not addressed in this ordinance, we welcome the development of a legislative solution and a work group as proposed to resolve this issue, as 43 states and over 430 municipalities have done. We strongly encourage the city to work with stakeholders to discuss these outstanding issues and to create a sign ordinance that is favorable to our business climate and provides a fair process. Doing so will ensure advertising opportunities are available to the businesses we represent and can also provide significant and public benefits to the city. Thank you.
Thank you. Sean Bayless, are you still here?
Sean Bayless, Planning and Land Use Deputy for Councilmember Paul Koretz. Councilman Koretz wants to add his voice to that of Councilmember Kerkorian and Councilman Rosendahl, and feels that while he has in the past spoken against this ordinance, feels the proposed ordinance before you today strikes an appropriate balance for the city. More restrictive than our existing law, this ordinance will help stem the tide of visual blight in our city, which is why the council member is supportive of it. In the works for 4 years, this ordinance has been vetted, thoroughly reviewed by the city attorney's office, and is ready to move forward. We can't thank the planning department enough for its countless hours that it has poured into this effort, and the council member looks forward to voting for the proposal.
Thank you, sir. Okay. I believe that concludes public comment. All right. Well, one, I did want to respond to the issue of how we look at the legalities of the administrative process, and I'd like to have those issues addressed to the city attorney. If you could respond to the legality when we speak of the fines and the issues that were raised by some of the speakers. If you could just research that and respond to them in terms of the legalities and what we can and cannot do in conformance to our practice here as a city when it comes to penalties. Okay? Any questions, my colleagues? 'Cause I do have a set. Directives, if you want me to just jump into the directives, you have questions?
I have some questions.
Okay.
Yeah.
Well, the directives would be to, one, adopt the directives presented by the planning department. They gave us a whole slew of follow-up in terms of supporting taking this ordinance to the next level and allow us to address the issues of implementation. But with the question posed to the city attorney, provide for a response to some of the issues raised in terms of the penalties. So that's something we need some feedback on. Second, to adopt the recommendations that's presented by Councilman Krikorian's letter. The spirit is to have a series of meetings with stakeholders. We're going to try to keep that as tight as possible, but make it as transparent and as available and accessible to everyone. And I believe the planning department, along with CLA, will help create the structure for that type of input. And lastly, to approve and request the city attorney to prepare the ordinance as to form and legality. Those will be the three main directives to the planning department as a way to implement what we have in front of us. Colleagues?
Thank you, Mr. Chair. And first I want to thank the planning department for all the hard work put into this, particularly Ellen Bell, who I know you're working on this even before you're deputy director, and it's been a while. So you know the ins and outs of how to distinguish off-site from on-site and fine art from public art. So thank you so much for your work. And I think this puts us on the path. It's a giant leap in crafting more sensible, workable regulations. Once we put this on its track, then we could move forward and deal with some of the other major issues as well that were brought up today in public comment. But certainly having this ordinance in place will help us deal with some of the other difficult issues that we have with crafting some sensible regulations with respect to signage. One of the things that came up today was the penalties, and I know our chair has asked our city attorney to look into the legality of the proposed penalties. But from a policy point of view, can I ask the department how you came up with these and why these proposed penalties?
Yes, and thank you for the acknowledgement, Councilmember Huizar. It's very much appreciated. Everything about signs seems to be extraordinary, and that the city needs to take extraordinary measures in order to enforce its sign regulations. As has been pointed out, the profits and the revenue potential for off-site signage are truly mind-boggling if you look at some of the figures. And in order to give the city the best arsenal to enforce its sign regulations, we looked at what other cities have done. In particular, New York City trailblazed this particular model of administrative civil penalties, and they have had great success in taking down off-site signage. San Francisco also has a model. So we took our cues from those other cities, and understanding the unique nature of signs. It's one can put up an illegal sign literally overnight. That's not quite the same thing as putting up an illegal building. And the process, we have taken many suggestions from the sign industry to make sure that there is a thoughtful, deliberative due process. Those provisions have been incorporated into the draft over many meetings with the sign industry. But at the end of the day, we believe that this is an important tool. One of the things I want to point out in terms of this particular ordinance is that sign companies have 15 days to cure the violation. So the penalties do not accrue until day 16. And we believe that 15 days is sufficient time to take down the sign or to cover it up, because what the ordinance says, if the sign company removes the copy, they cover it up with a sheet of vinyl, then at that point, the penalties do not accrue. What we don't believe is advisable is to allow sign companies to keep up the illegal signage and continue to accrue and generate significant revenue while there is a protracted legal process and appeal process. At that point, the sign company has a built-in incentive to delay and drag out the appeal process rather than allowing the city to quickly resolve the issue and answer the question, Did the sign company violate the law and put up an illegal sign? What we think would happen is that if they receive an order to comply and they are given the 15-day cure period, and on day 16 they tell the city, no, we're just not going to take down the sign, period, we're just not going to do it. At that point, the city, I think, would be certainly within its rights to say, well, we have these penalties, and we are going to impose these penalties during the appeal process. So I think that we have a thoughtful, well-balanced enforcement mechanism. Certainly it has been a tribute to the current city attorney to take significant enforcement actions, but again, that is at the discretion of the current elected city attorney. I believe in putting it within this ordinance, the council is declaring its legislative intent and its legislative priority to take these measures as is necessary to ensure that we have the capacity and the capability of enforcing the city sign laws, and the city really truly means business.
So in your opinion, do you think these penalties are excessive?
I do not.
And how do they compare with other penalties that you are familiar with in building and safety or any other type of industry that we deal with as a city? Well, there was a comment made that there's nothing like this in any other portion of what the types of penalties the city gives out. Would you think that's an accurate assessment?
That is absolutely true. Under the municipal code today, any violation of any section of the municipal code, whether someone puts up an overnight fence that, let's say, is 4 feet when the code says it's 3.5 feet, the city can impose a penalty of $2,500 a day, and that's in the code today. Those penalties, however, and maybe the city attorney can correct me if I'm wrong, based upon the drafting of those penalties, the city actually doesn't even get to keep those fines. I believe because they are considered misdemeanors, they go to the state. The administrative civil penalties that we are proposing, because they are administrative civil penalties, the city can keep those fines, and they can be addressed certainly in terms of the city's general fund and its budget. So in terms of how do they compare to other penalties, yes, they are much higher. I believe that that is because of the two reasons. One, the ability to put up an illegal signage so quickly in a matter of hours. And secondly, because it's so easy to cure the illegality by taking it down very quickly or covering up, that this is justified. We have seen all across the city over the last few years instances of sign companies openly flaunting the city's ban without any recrimination or without the city having the ability to take action on it. And this is trying to level the playing field between the city and the sign companies.
Okay. Thank you. And Mr. Chair, last week we adopted a mural ordinance that has yet to make its way to the full city council, but I'd like to ask that the city attorney identify any provisions of this draft ordinance that may be inconsistent with the instructions given in the mural ordinance, and that we could look at those before either of these come up to council.
Okay, so would you be asking both ordinances to come back then? Or?
No, I'm just asking that before either of these get to council, if we could see if they could be consistent with one another.
Okay, I believe that they are already, because it's the same team that's been working on both of them.
Okay.
I do want to also, just to clarify for the record, I believe that there was some confusion in some of the testimony. The penalties that we are recommending only apply to illegal off-site signs. They do not apply to any violations of the on-site signs, and they certainly would not apply to murals because, as you know, in our proposed mural regulations, we took great care to make sure that murals were not defined as signs, and as such, they would not be subject to any of the sign penalties under the drafting language that we have put forward.
Great. Thank you.
Councilmember?
First, to Alan and Daisy, I want to thank you both for putting so much effort and time and working with so many different stakeholders and interest groups, neighborhood councils, and the like. And you've put a lot of work into this, and it's reflected in your work, and it shows. So I think there's a lot of people on both sides of this. This is a very heated, emotional issue for many reasons. And at the end of the day, I think this room owes both of you applause, because you've done so much good faith work on this, and have taken the time. It's absolutely, I think the ones from the industry should be applauding you as well. The couple questions on so this doesn't deal with digitals at all, and I know that'll be coming back another time. And on the fine structure, I did have a lot of questions on that. You did answer them. You said New York actually has similar fine structure on off-site signs as well, so I was going to ask you about that, so I appreciate you answering that. And I certainly, a lot of my questioning was going to go into when the fines actually kick in. And what I kept hearing in previous conversations and reading from the drafts until we actually sat down to meet, it was stated even from a lot of the community folks and even from some of the companies themselves that takedown meant that it was interpreted by some that takedown would actually mean they'd have to physically take down the structure within 15 days. And the clarification for the record is critically important, that it's taking down the copy or covering it up. And so in fact they can keep it up for 2 weeks. They have got that grace period, if you will, to either correct the violation and or cover it up pending the outcome. Now the hearings, one of the speakers, and I can't remember which one on what side they said it, but it made a note, said it could take 6 months to a year sometimes in hearings. Is there any type of, with building and safety, an expedited hearing that they could pay for or opt into so they could guarantee a faster outcome?
That was one of the suggestions from the sign industry for expedited appeal process. We have crafted and included within this regulation an expedited appeal process that would allow the director of planning to appoint an administrative hearing officer who is not necessarily a city employee, but who would be a qualified individual to make sure that the appeal could be heard on an expeditious basis. The planning department, using this expedited language, which is included in the ordinance today, by using non-city employees who are qualified hearing officers, there would be additional cost, and the appellant would be charged with responsibility of paying the additional cost to the department to conduct that expedited appeal.
Okay, so that's possible. Excellent. And then maybe we can use that model for other types of hearings as well and appeals. One of the speakers mentioned also that the reduction portion of the takedown may not be fair or equitable if it's a smaller company versus a larger company that has more of an inventory. But in keeping with the community in mind first, if there's a community that says, no, we would actually welcome a sign or two here in lieu of takedown to add to either beautification or graffiti abatement, or how can those particular locations with this be addressed or negotiated? Is that allowed in this provision?
Going back in terms of there's the basic ground, so let me answer it this way. So what the Planning Commission had recommended, that the only option to be allowed on the table was sign reduction, and the Planning Department recommended that only sign reduction be on the table. What the committee deliberated on was that within the downtown area, because of the uniqueness of the downtown setting, that it could be either or, either 50% sign reduction or 50% community benefits, but that in other sign districts, that because this is one of our few opportunities to reduce the existing inventory of signs, we know what we're getting, we can quantify it, we can measure it, we have 6,000 billboards, that first preference again be given to sign reduction, but that 50% of the total value could be substituted through community benefits, and that as each particular sign district goes through the process, that the exact ratios, the exact bundle of benefits would be approved by the City Council. Again, each sign district has to go through its own legislative process. It's a policy issue at heart. We believe that this is best reflects the language and the framework enunciated by the court in World Wide Rush, that we improve the visual environment. And the planning department's belief is that the more that we can take down existing signs, and this is our only opportunity, is through sign reduction. The other community benefits or other mechanisms, development agreements that we can use to do that, but this is our best and single best opportunity to facilitate sign reduction, and I believe that the neighborhood councils and neighborhood groups have really advocated stronger provisions for sign reduction. As far as the technical feasibility of it, the truth of the matter is that secondary markets can be established among sign owners and sign companies to facilitate that sign reduction. And I believe that as we go into the second phase of this process in the working group, we would be able to get additional advice in terms of the mechanics of that sign reduction. Again, speaking for myself, I believe that we have multiple opportunities in the city to get community benefits through other mechanisms. This is the only mechanism that we have to take down signs, because state law says if you want to order the takedown of a sign, you have to provide just compensation to the sign owner, which would mean we have to pay an astronomical amount of money to take down a sign. So this is our best opportunity to do that.
Okay. And then just to quickly, and as that second phase comes through, if you that's going to come back here as well? Okay, so we'll focus on that issue. Mr. Chairman, was your intent to include in your suggested report backs, there was some discussion about the issue of the illumination that we had early on in the conversation, where they were going to come back in 30 days. I just want to make sure that was picked up somewhere.
Well, we do include brightness standards.
Brightness standards.
And
okay, I thought that was amongst council members, but I guess we're on the side.
We listed that in our recommendations.
What time of day?
Okay, so that'll be included in there. Okay.
All right.
And then the rec and parks issue where we had them as well.
That gets folded in.
That's going to be folded in as well to make sure that that's captured.
Right. Terrific. And colleagues, just to put in perspective, since 2009, we've had 8 plum committee meetings on this. 8. So that's a lot of work from the staff, a lot of work from all the different stakeholders. And along the way, we had to deal with some court issues. So that's a part of the tension here, and try to get some policy based on parameters set by the courts, and we finally have that. So that was a big step. When I was referring to the legalities of what was being raised in terms of implementation and fines, they were focused on those signs that are deemed legal as opposed to illegal, and that's what we're going to get some clarity on, correct? Right, Secretary? The issue of fines and looking at the amount of fines and how much we're charging, the questions raised during the committee.
Yeah, my understanding is that the direction to the city attorney will be to review the administrative process and to respond to any legal issues that arise.
Okay. All right, I don't see any other questions from my colleagues. We've been through public comments. We have the directives to approve and request the city attorney to prepare the ordinance as to form and legality, to adopt the recommendations presented by Councilman Krikorian, and to adopt the directives presented by the planning department. I have a second on that? Second? That'll be the action of this committee. Congratulations, folks. We have a base. Thank you very much. Anybody here for public comment? Seeing none, this meeting is adjourned.
I mean, obviously, you got the
How are you?